in the matter of Packham and the Secretary of State for Transport and others.
Now, Mr. Wolfe, I don't have an image of yourself on my screen.
Good morning. Maybe if I speak.
Yes, that's it. Thank you. I can now see you and hear you. Mr. Mould, I can see you. Can I make sure that I can hear you?
I'm here, my lord.
Thank you. Others present will be your juniors, as I understand it, though they're not shown on the screen in front of me at the moment.
As I understand it, my junior is certainly is logged on.
I see. And Mr. Wolfe? Good, thank you. And those instructing you are also connected appropriately to the proceedings, I'm assuming, but could you just confirm that, please?
Yes. I think that's right, yes, as far as I can see.
There are two guests, I think, at least, present in this connection, as well as the live streaming arrangements that I will mention in a moment. There may be other guests as well.
Good morning, my lord. My name is Alison Kershaw. I'm here from the Press Association, just to let you know that there's a reporter here.
Thank you very much. Thank you, Ms. Kershaw. Good. Can I mention the live stream arrangements for these proceedings? It will be widely known that these proceedings relate to the HS2 project. They are therefore of widespread interest and concern to a very large number of people. The court is conscious of that, and the court was asked on behalf of the applicant before us whether live stream arrangements could therefore be put in place. That seemed obviously sensible to the court, and appropriate arrangements have been made. And thus, these proceedings are being live streamed to a very wide audience. The court has taken every step that it can to ensure that that will operate smoothly. It is not perfect, of course, but in the present circumstances, it is the very best that we can do, and we believe that it is an appropriate and adequate way of transmitting these proceedings to that wide audience. It must be stressed, however, and I must emphasise this at the outset, that no recording of these proceedings may be made other than by the court itself. It is very important for that to be understood and to be respected, please. This is a remote hearing, although two of the judges, myself and Lord Justice Haddon-Cave, are present in a courtroom. It is nevertheless a remote hearing in its totality. The third member of the Constitution is physically remote from the court, Lord Justice Green, but he is connected and present on the bench with us in that remote form. Can I ensure that all of the arrangements are clear to the advocates before us?
Yes, thank you very much, my lord.
And Mr. Wolfe?
My lord, yes, all absolutely clear. Just two things. One, I can't at the moment see the other members of the bench. I don't know whether they will appear if they were to say something. And the other thing, just to forewarn you, is that my normally very stable internet connection has been a bit quirky this morning, so I may need to at some point turn up my microphone, so my video, to optimise my bandwidth, but I'll only do that if absolutely necessary.
All right. It may be a good thing for us all to get into the habit of doing in the course of the day. When we're not speaking, turning the microphone off is sometimes a way of increasing bandwidth, I've found. So can I suggest that? I'm not asking positively for it to be done, but I'm suggesting that it should be done.
You might like to pin me to a screen. Mr. Wolf, you may like to pin me to your screen if I come up.
I see you now, my lord.
Mr. Mould, I assume that you can also see Lord Justice Haddon-Cave,
I can indeed, thank you.
and I'll ask Lord Justice Green to do likewise, if he would be so kind.
Yes, I can see everybody.
And I want to be sure that Lord Justice Green can also be seen by the advocates too.
Can everybody see me?
I can see you now.
Okay, as can I. Thank you.
There you have it. The three members of the Constitution, all visible and audible to counsel. Now, I think that does complete the necessary preliminaries, and we can get underway. Can I deal first, Mr. Wolf, Mr. Mould, with new evidence which has come before the court in recent days from both sides in the form of a series of witness statements produced by the first respondent and interested party, and then a response by way of a witness statement of Mr. Short for the applicant. Submissions have been made in writing, inviting the court on either side to admit that evidence. The provisional view of the court is that without reaching a formal determination on the application to admit fresh evidence on either side, the court is minded to receive that evidence de bene esse, that's to say that it will have the evidence before it without reaching a concluded view at this stage on its admissibility, on the basis that some of the material seems on the face of it to be admissible, some of it arguably not, and some of it perhaps definitely not. But without using valuable court time at this stage in deliberating on that question, the court is minded to proceed in the way that I've indicated, but we will hear from either side as to whether that is regarded as an appropriate way forward in the circumstances. Mr. Wolf?
Well, I'm very content with that. I will refer you to the relevant elements of the evidence as we go through, but I can tell you on that basis.
And Mr. Mould, thank you.
My Lord, the only point I would make is that we had understood from the order of Lord Justice Lewison that we had permission to file witness statements in response by the end of last month. And the three statements to which you refer on behalf of the respondents and the interested party were filed on that basis. I accept, of course, that if the court takes the view that there is within that evidence content which is not relevant to the issues before the court and therefore not to be taken into account on that basis, then that is an issue which remains at least in principle open to argue. But we did proceed on the basis of the direction made by Lord Justice Lewison when he considered the case in the papers.
Well, we take heed of that, but subject to that important point being remembered, are the respondents and interested party content for us to proceed as I've indicated?
Oh yes, indeed, yes.
Thank you. Well, then the court will proceed in that way, and the parties are at liberty to refer to the material which has been physically produced to the court, but not formally admitted at this stage at least. Very well. I think those are all the preliminaries I needed to attend to before we get into the argument itself. Can I assure the advocates and all those in attendance that the court has read the material before the court and is familiar with the arguments helpfully set out in skeleton arguments in the normal way by the advocates on either side. And that can be assumed for the purposes of the oral submissions that we will now hear. Thank you. Mr Wolfe.
My Lords, good morning. As you will have seen, I appear with Ms Mary Golden for the applicant in this matter. Mr Mould and Ms Lean appear for the respondents. As you, my Lord, have already indicated, this comes before the court pursuant to an order from Lord Justice Lewison. He made an order for a rolled-up hearing in the light of the Divisional Court's decision in April. Well, Lords, unless you tell me otherwise, I imagine that you want me to proceed on the basis of making full submissions, and you will then,
Yes.
in the light of those submissions, deal with the various sort of salami-sliced steps that are involved in a rolled-up hearing.
Yes, that is the right way to proceed. You're quite right, Mr Wolfe. That is what the court would like you to do, please.
I'm very cool. Well, you will have seen then that the decision under challenge is a decision announced on the 11th of February of this year.
Yes.
You have the announcement of that, and I'll come back to it later, but you have it for now at the back of the core bundle, pages 140 is the beginning of the section. I won't take you to it for now in any detail.
Yes.
It was a statement by the Prime Minister announcing a decision to proceed on the part of the government overall with the HS2 railway project, phase 1 of which has in effect planning permission by operation of the 2017 Act. My Lords, you will have seen that our challenge before the Divisional Court, or at that stage the application for permission and an injunction, raised a number of grounds.
Yeah.
You will have seen that we proceed on only 2 of those, ground 2 and ground 3B, as they were before the Divisional Court.
Yes.
That changes things somewhat when we come to issues around timing and so on. And also you will have seen that things have moved on in time terms because the urgency of the matter as perceived in April, immediately as it was before some works were to be undertaken destructively to some ancient woodlands, that urgency, or that immediate urgency, has gone away because works are now paused in those regards until later in the year, and that explains Lord Justice Lewison's helpful timing, order, and so on.
Yes.
Well, we come before you with what we hope are some very conventional, let me call them light touch public law issues,
Right.
that require you to decide a relatively small number of propositions, which I'll come to as we go through.
Thank you.
My Lords, I don't therefore believe we are in any way pushing the boundaries of what the court sometimes asks to do on judicial review, and I know something which troubled the Divisional Court in these proceedings. My Lords, by way of a background to these matters, and I can take any of these in more detail if you need me to, that the background here is of course the High Speed Rail Act of 2017. You have that in tab 3 of your legal materials bundle. I wasn't proposing to take you through it in any detail. I simply invite you to note this is within tab 3. In effect, 2 particular provisions. I'm not sure if my Lords are using a PDF bundle or a physical bundle.
But those of us in court, Mr Wolfe, are using physical bundles. I think Lord Justice Green may be. I think he may be using an electronic bundle. He is. He's indicating.
If it assists with an electronic bundle, it's page 20 of the PDF. The 2 principal provisions of background context here are section 1 of the 2017 Act, which gave a nominated undertaker the power to construct phase 1 of HS2.
Yes.
And then next page of the printout, section 20, which gave it deemed planning permission for the purposes of the 1990 Town and Country Planning Act. In other words, there is permission for the developer, to proceed with this project. And also in the clip you have information which shows that, consistent with a grant of planning permission, there had been consideration at that point, as if part of a planning system, of impacts of the proposals.
Yeah.
However, my Lord, and I don't think there's any controversy in this regard, much had changed since then. Even in the relatively short time between 2017 and 2019, things had changed. That mattered here for these purposes because the government, by virtue of its ownership of HS2 Limited, the nominated undertaker, is in effect the developer. And so what that led the government to do, entirely properly in its capacity as developer, was to contemplate a decision as to whether to proceed, and if so, how to proceed, with the HS2 project including within that phase 1 in particular. That is a freestanding public law decision, of course not underpinned by any specific statutory framework, point made by the respondents against us, but nonetheless a decision subject to a judicial review analysis of the kind we contemplate. Not required to take the decision, but if it did, the government would decide required to take one on a lawful basis. In order to assist it with that process, the government set in place what has become known as the Oakerby Review. In supplementary bundle at page 40, you have the beginning of the Oakerby Review process.
Yes. Shall we look at
I know
that?
the court will have looked at these documents already, so I only propose to draw the court's attention to what we regard as the relevant highlights.
Yes. Thank you.
You have two documents here of the 21st of August. SB 40 is the announcement document, effectively the Department for Transport's announcement of the Oakerby Review process, explaining in the box just below the picture of the train, first bullet point, the government's publishing the terms of reference for independent review, chaired by Douglas Oakerby, into whether and how to proceed with the HS2 project. So very much, not simply on mechanics and detail, but also on the principal question, the whether to proceed question. The Department of Transport announced, and no doubt the Secretary of State and others reading this were contemplating, the terms of reference set out at the foot of page 40. An independently led government review will look at whether and how HS2 should proceed, using all existing evidence on the project to consider, and then over the page, a number of things.
Yes.
And then goes on to say in the first full paragraph, a final report will be sent to the Secretary of State, together with oversight from the Prime Minister and the Chancellor of the Exchequer by the autumn. The report will inform the government's decisions on the next steps. Now, just to be clear, we are not saying, we've never said, that there was any suggestion that this would ever be the only source of information on the basis of which the government would act. The question, though, is how the decision makers would have understood the information that was then provided to them. We then have two quotes, one from the Transport Secretary, Mr. Grant Shapps, second paragraph within the quote, referring to a rigorous review of HS2, and then below that, Douglas Oakerby and his expert panel will consider all the evidence available and provide the department with clear advice on the project. And then, likewise in similar terms, Mr. Oakerby explaining that he would advise on whether and how, based on all existing evidence. So the reader of this material would apprehend that everything was going to be considered by the panel, including all existing evidence, in order to inform its recommendations. Same day, and what was in effect being produced by that announcement, starting at page 42, the terms of reference for the independent review, the guts of which comes at page 44.
Yes.
Inevitably, to some extent, repetitious of what we've seen before. The opening paragraph repeats the assembly and testing all of the evidence points. And then the second paragraph says this: for the whole HS2 project, the review should rigorously examine and state its view on, and then second bullet point, the full range of benefits from the project, including but not limited to, and then the fourth sub-bullet, environmental benefits, in particular for carbon reduction in line with net zero commitments. You will see the relevance of that to the submissions I'm going to make in due course. I'll leave it there for now. And in the next main bullet, the full range of costs of the project, including but not limited to. So the impression given was of a not just wide-ranging but comprehensive assessment of all of the pros and cons, an entirely properly contemplated activity. Well, what you then have, not much later, that was the 21st of August, the 3rd of September, at page 46 in the supplementary bundle, the Secretary of State gave what was described in its heading here as an HS2 update. A written statement was made. He explains, end of the second line of the first paragraph, we have been equally clear that the costs and benefits of those investments, that's a set of transport investments, must stack up. So what is being announced quite properly is a cost-benefit appraisal of a range of activities. 2 paragraphs further down starts the chair. The chair will be supported by Lord Berkeley and a panel of experts from business, academia and transport to ensure an independent, thorough and objective assessment of conclusions. And then 2 paragraphs further down, HS2 is the single largest project for this government. One important aspect of the panel's work is to consider whether both the costs and the benefits of the scheme have been correctly identified. And then the next paragraph, I want the House to have the full picture. There is no benefit in obscuring the true costs of a large infrastructure project, as well as the potential benefits. All of that is entirely proper and entirely welcomed as being an open-minded evaluation of the pros and cons of this project. No sense there that anything will be left out of the appraisal or treated as being a given. You then have, and this is referred to in the context of the De Bene essay, indication that the court's already given, similar other indications given by the Secretary of State. I won't take you to them. They are set out in Mr. Short's witness statement at paragraphs 5 to 14. He extracts the relevant passages there, and he exhibits the relevant statements in Parliament and answers to parliamentary questions and debates from the Secretary of State, all reinforcing the open mind, blank sheet of paper message that we've already got from the documents we've seen. And that's partly why I don't need to take you through those additional materials. Well, in terms of what people then said to the OKB review, you have in the bundle, starting at page 48, a selection of documents from a number of environmentally concerned organisations, some of which have a national reach around a particular concern, whether it may be birds or woodlands, some of which are geographic, like the first one we have in the bundle, the Chiltern Society. Well, I don't propose to take you through those in any detail, save to identify the scope and nature of some of the points that these respondents were making. What is notable about this process, and there's no legal issue here, is that the OKB review didn't specifically solicit responses or information. There wasn't a call for consultation or anything like that, but various people, it's very clear, from a range of perspectives, submitted information, and we see in due course that was then taken into account by the review process. So what you have in the Chiltern Society document, for a start, at page 49, middle of the page, it is an outline of some of their concerns about environmental harms caused by this would be HS2 phase 1. And then environmental related harms under the heading geology at page 50. So a fair amount of information there, but in a pithy and digestible form. You then have next document, just to pick up a couple of points here, SB 52, Wildlife and Countryside Link, a coalition of environmental groups. They make the point, this is in the third paragraph, in the lower half of SB 52. They refer in that paragraph, if you look about 2/3 of the way down the paragraph, to the consistency or the compatibility rather of HS2 with government policies such as the 25-year environment plan. That is relevant because the 25-year environment plan is a government policy doing, as it says on the label, plan for the environment lasting 25 years, that was only produced in 2018. So they are drawing attention to more up-to-date policy provisions than would have been in play in the 2017 period, or indeed the 2012-2013 period, when the bill had been going through Parliament and there had been environmental appraisal then. You then have, at page 54, the Woodland Trust submission. Their particular focus, unsurprisingly, is on the loss of ancient woodland. And at 55 and following, I won't take you through the detail of it, they set out some important information about ancient woodland. Important because I think it's fair to say that the ordinary person wouldn't necessarily know the significance in terms of its environmental importance of ancient woodland. So the points they make there in an accessible form, describing the nature of ancient woodland and their concerns about it, are an important part of the picture.
Yeah.
You then have at 70 the RSPB submission. RSPB obviously big focus on birds and their habitat. within that, they make the point on page 70, middle of the page, that it's important to consider the environmental harms as well as the benefits of the proposals. And then on page 72, under the heading biodiversity, the paragraph in the middle which starts impacts on wildlife, makes comment on the past assessment, and in effect says the past assessments were, they use the word amongst other things, over-optimistic. So they are critiquing the past assessments in a way that entirely plays into what the court sees as to be the terms of reference for the Oakerby review, the testing all existing evidence. And then the last document in this suite that I'll ask you to have in mind is page 77, a document produced by the Wildlife Trusts, so that's the national, as it were, federal parent of all of the local county-based wildlife trusts. And what they there set out, and I'm not going to for a second take you through it, is in 28 pages, and they take the reader through an appraisal of the environmental impacts, including, perhaps most obviously at page 85, a section called Findings, and they identify a series of statutorily protected wildlife and nature conservation sites that will be harmed by HS2. So that is the kind of information that was provided to the review in order to assist it with the process of testing all the existing evidence. We then jump to the end of the review process in our chronology, and if I can pick it up then at page 244, please. This is the departmental announcement of the review report. This is the 11th of February, published at the same time as the report, and on the same day that the Prime Minister made the announcement. There wasn't any advanced publication of the report, it simply came at the moment of announcing the decision. Reminds us, under the heading, the big letters, Oakerby Review, that the review sets out the independent review's advice to government on whether and how to proceed. So they have done that job, the whether and how to proceed job. And then under the heading Details, second paragraph, the review was asked to assemble and test all the existing evidence to allow the Prime Minister, the Secretary of State for Transport and the Government to make properly informed decisions on the future of phases 1 and 2 of the project, including estimated cost and schedule position. And then the last paragraph, the last 9.5 on the page, independent, thorough and objective assessment. Now, in other words, they have explained that they have done, or this is announcing that they have done what they were told to do, assemble and test all the evidence to provide a thorough assessment. So nothing in there that would lead the reader of any of this material to think that this was in some way an incomplete assessment, or that they needed to look elsewhere to supplement their understanding on any of the topics that were relevant to that process. Before I turn to the review report itself, which you have at page 114 in that bundle, I just draw your attention to perhaps what is, doesn't need too much elaboration. It's an observation by Mr. Justice Dove in a case you have at tab 17 of the legal materials bundles. It's page 242 in the PDF. I want to jump to that document, or 269 is actually the paragraph, 269 of the PDF is the paragraph of interest, paragraph 43 of the report. The last few lines of paragraph 43, Mr. Justice Dove, they're talking about how the public will understand a consultation document, but we say the principle is the same. It's a reasonable reader test. It's a reasonable reader test. So we say that when then comes to the Oakerby Review report itself, we apply that reasonable reader test. What would the reasonable reader, understand that they were being provided with, and on what basis?
Yes.
Turning then to the Oakerby Review report itself, this is supplementary bundle, page 114, is the beginning of the report.
Yes. We're putting the authorities bundle away for the
Put the authorities bundle away, please, yes.
Right. Just a second.
I forget that for those of you with physical bundles in court, it's not quite so It's a different process.
It's a different process. That's it. Yes, thank you.
Review report itself starts at page 114. The chair's forward starts at 116. And again,
Mr. Paul, I wonder if I could just ask you a question rising out of an observation you just made. To what extent do you view the TOR as leading to a consultation process? The TOR are largely required in review committees to look at the existing evidence. I think it's plain from their report that they did actually canvass and use more broadly, but it wasn't a consultation in the more traditional sense, was it? Or do you take it was?
no. I mean, we don't take any arguments about the common law requirements for a consultation process and whether they were met or not met here in that way. There was a hint that views would be welcomed, but in any event, views were sent in. But more importantly, what we see from the report, and I'm about to show you some examples of this, is that the review panel appear to have looked at those reports. What matters for the purpose of our submissions is the way in which they then report that process to the reader. It's not so much whether that process was a good, bad or indifferent one, it's what impression the reader has of the process adopted by the report which matters for my purposes.
Thank you.
And indeed that's exactly the point I'm about to take you to on page 116. Second paragraph in the chair's forward says this: the short duration of the review meant we did not conduct a formal call for evidence, but instead canvassed the views of a wide variety of interested parties, all with different perspectives, both for and against the HS2 project. Missing out the next sentence, we're grateful to many organisations and individuals who've written to us expressing their views. All this information has strengthened this report and my recommendations. We then, and I'll take to this at the end of the document, we have the list of the many individuals and organisations who sent in materials, including the ones I've just shown you. And the important point from my perspective is that the reader gets the impression that what those organisations have said has been taken into account and is in some way reflected in this report. Or rather, to put it the other way around, there's nothing here to say we received, you can envisage a situation where lots of unsolicited material was sent in, but the answer was we're grateful for the unsolicited material, but it's not relevant to our task, so we put it to one side, and that's the end of it. We're very much not in that latter situation, and that's what matters for the purpose of my submissions.
Right.
The other thing on that page, just drop into the next paragraph which starts given the limited time available, the review has faced a major challenge to undertake a deep examination of all of the areas, including the terms of reference. I believe the review has, though, provided views on the key issues. So again, the impression given is that this provides sufficient information on, quote, the key issues. And when we come to see what the key issues were, that plainly includes, amongst other things, climate change impacts and environmental harms. At page 118, into the introduction to the report, paragraph 2.1, this is a paragraph actually that's relied on, just as a side point, relied on by the respondent in resisting the admission of Mr. Short's evidence, because the respondent says quite rightly that what this paragraph says is that this was a controversial proposition and that the decision wasn't a clear-cut one. It could have gone in different directions. So we recognise and agree with that proposition, if you like, from the respondents, and it's reflected in paragraph 2.1. The review has seen evidence for both extremes, but in reality the position is much more nuanced. That's both about the principle of the project and how it goes ahead. It is not a straightforward binary question by any means, and nor was it a clear-cut question by any means. We're then told, paragraph 2.2, the review has looked from multiple perspectives. This would be the key issues point. And the fourth bullet there is the environmental case for and against HS2. Just pausing for a second there. That would lead the reader to the understanding that they were getting the environmental case for and against HS2. None of these things we take in isolation, of course. They're all taken together. But they are all, we say, consistent. There's nothing there that says you've got to look elsewhere for your understanding of any particular aspect, or indeed the environmental case. But it then goes on, particularly in the light of the government's recent commitment to net zero carbon emissions by 2050 and the impacts of the construction of HS2 on the environment. So quite properly and helpfully explaining that it's, as it were, setting out the environmental case, including on the climate change point by reference to net zero. And you will appreciate that the elements of that are important kicking off points for the submissions you make in due course. Then on 120,
I wonder, my lord, just to save time overall, if Mr. Wolfe wouldn't mind drawing the court's attention to paragraphs 2.3 and 2.4 on page 119.
of course, very happy to do that. So 2.3, it's important to note any examination of a project doesn't start from a blank piece of paper. Phase 1 of the project had 10 years of design, public consultation, length debate. Phase 2 is an earlier level of maturity, and here they're focused on finalising route design, station locations, integration with other transport projects. So it's no doubt that the reader would realise that there had been an examination of HS2 Phase 1 before, and that there was going to be a more detailed examination of Phase 2 in the future. No doubt about that. But the important point from our perspective is that there's nothing there to suggest to the reader that they need to look at those materials, including in particular anything arising from the assessment of Phase 1, in order to inform themselves here. And I'll make some legal submissions about the way that works shortly when I come to look at the decision-making process. But the impression given by this document is that whilst it recognises that there have been other processes, it is the document which is telling the reader what they need to know. And then 2.4, it should also be noted that given the instruction report in the autumn, there was a limited amount of time to carry out the review. Evidence was considered by the review largely over the course of September. Following this period, HS2 Limited and DFT and others may have further refined and built on the evidence originally provided for the review. Those are the passages that Mr. Malton wanted you to see.
Right, thank you.
Then at 120, paragraph 2.8, when you're coming to its view on whether and if so, how to proceed with the HS2 project, the review in particular considered the following key points, and within the bullet point list, at the top of page 121, with the emphasis on this, HS2 could help deliver the government's commitment to bring all greenhouse gas emissions to net zero by 2050. The net zero commitment was made only in June 2019, well after HS2 was initially proposed, and indeed after the Phase 1 Act achieved royal assent in 2017. We get several things from that. But first off, that the net zero contribution is being seen as a benefit of HS2. Secondly, however, that it's only the net zero aspect of climate change legal obligations that is mentioned. Come to that in due course. And thirdly, quite sensibly and properly, what is being taken into account for the processes of this panel and this report is the up-to-date position, the amendment in 2019 of the Climate Change Act, which you'll see shortly. So there's no sense that things are frozen in time in 2013 or 2017. Quite properly, this is an update, but it's an update only by reference to one aspect of the climate change obligations that we have in law. At page 124, the executive summary, in a sense repeating a point I've already made, but by reference to the overall conclusions box, top of 124, last sentence in that box, in providing its view to the government, the review considers that, on balance, ministers should proceed with the HS2 project. So this was by no means clear-cut. This was on balance. That's obviously relevant in due course to the respondent's section 31 of the Senior Courts Act argument, as is the point I showed you earlier on the more nuanced point, the quote's more nuanced point. In terms of the structure of the document, we then have at page 137 is a section called, or a chapter called Review of the Objectives for HS2. So this is in effect presenting what it calls the strategic objectives, the benefits of the project. Within that, one of the benefits identified at page, paragraph rather 5.30, page 149, is the heading Wider Environmental Considerations.
139.
That means climate change impacts.
Sorry, where were you again?
So it's page 149.
149, sorry. Misheard you.
Para 5.30 and following. And we're here concerned with the section from 530 to 537. So what the reader and what the decision maker is told is that in June 2019, the UK government committed to bring all greenhouse gas emissions to net zero by 2050. That is correct, but that is only, if you like, half of the relevant legal commitments, because as you've seen, and I'll show you again shortly, the legal commitments are not simply about the spot result of what's achieved in 2050. It's also, if I can put it colloquially, how we get there. How we get there. So the reader is told about the legal position in relation to 2050, but only that. 531, the reader is told the factual question, which is that during its construction phase, HS2 is forecast to add to carbon emissions. There's a little bit of information about why that's the case. They are told the factual position. So we have never suggested, as the Divisional Court seems to apprehend, that the decision maker was not told that fact in overall terms.
Yes.
What matters, though, is their apprehension of the legal significance of all of that. Just in terms of the scale of all of those things, the respondent, particularly in its recent evidence, makes various points which, by contextualising that into the overall UK carbon production, the overall greenhouse gas impacts, tries to talk down the scale of all of that. Now, that submission needs to be seen in the context of what we see over the page, in the following pages, which is that when we get to 5.37, and I'll come back to it earlier paragraph in a second, I've made this point, 5.37, we see that the negative construction and environmental harm impacts approximately balance the greenhouse gas benefits of running a train system in due course instead of people driving and flying. So the scale and impact of the construction and environmental harm impacts then are not so small as to not be the same as the benefits arising from the operation, and the benefits from the operation are the ones that are then trumpeted as being a benefit. Now, we don't for a second say that those aren't environmental benefits, but their scale in broad terms, and we get this from 537, is essentially numerically very similar. Overall, this project is going to be climate change neutral. The difficulty, though, is that if we just go back, if I may, to 533,
Yeah.
in 533, the reader, the decision maker, is told in the closing lines of that paragraph, last sentence in particular, HS2 should be considered carefully in the role it could help play in meeting this target. That's the net zero target. So what the reader is told is that there are short to medium term climate change harms, long-term climate change benefits. They more or less balance numerically. They are told about the legal implications of the long-term benefits, the net zero contribution, but they are not told anything about the legal implications of the short-term and same scale climate change harms. And that is the kicking off point for the submission in ground 3B, to the effect that they did not take into account, as they needed to do, the Paris Agreement obligations, or to move the debate on in the way that the respondents want to, the Climate Change Act carbon budgets, which give effect to those matters. Whether you characterise it as Paris pure and simple or Climate Change Act carbon budgets, the decision maker did not realise, was not told, that what they were contemplating here would potentially bring net zero benefits, a legal benefit, but they were not told it would also definitely bring carbon budget hardships. So that's the section that deals with those elements. In terms of the other environmental harms, so I should say, final paragraph I made there, page 152, under conclusion 5, message, that message is reinforced in conclusion 5 on page 152, where the reader is told the government's 2050 target has placed a new emphasis on the design, build and operation of the HS2 network, and then that's explained. So what is emphasised to the reader is the net zero benefit, but without the Paris-stroke carbon budget detriment. The other aspects of environmental impacts, the non-greenhouse gas emissions, come in the section, or the chapter 6, which starts on page 154, which is headed Design and Route. And within that, at page 158, is a heading Localised Environmental Impacts, which between 6.14 and 6.21 gives a very high level appraisal of some, but by no means all, of the legal impacts, the environmental harms caused by clearing the route and then constructing the HS2 railway phase 1.
So this is 614. Sorry, 614.
614, yes,
Yeah, thank you.
614 and the following paragraphs.
Yeah.
We have said repeatedly in the court document, starting with the pre-action letter, that this does not provide an overall or sufficient appraisal of the environmental impact of the project for the purpose of this decision. And the respondents have never disagreed with that. They've never contradicted that proposition. They simply say, and I'll come to this in due course, that other environmental information is elsewhere. The difficulty with all of that, of course, is that in the light of what I've shown you, and I'll show you a bit more, the reader of these materials, understanding them in the context of the various public statements, the terms of reference and so on, would not have appreciated that this was an incomplete appraisal. Indeed, quite the opposite. They were told this had looked at the key issues, it had looked at all the evidence, and it was giving them what they needed to make the decision. So their understanding would have been that, of course, they knew that there'd been a prior environmental assessment process in the course of the legislative process, but they were not being told in any way, shape or form that they needed to look back at those materials to get the information they needed to make this decision. That is not an argument, as the Divisional Court appeared to think it was, about the scope in the abstract of what the decision maker needed to know. It's an argument about the basis on which the decision maker proceeded, their understanding of the information before them. Now, all of that could have been would have gone away if indeed this argument, this line of attack would have fallen away. If either, and there's a number of one of a number of things might have happened. If either, for example, the report had made clear that it was not a complete appraisal, not a sufficient appraisal, I should say, and that the reader needed to look elsewhere, as in we've looked at topics A, B and C, you'll need to look elsewhere for topics E and F to make your decision. That would have been perfectly proper, but that's not what happened. Or if there were evidence that the decision maker or decision makers had somehow been given that advice elsewhere. If we had been, the court had been provided with a ministerial submission or some other similar document which said to the decision makers, and we'll come to that in a bit, you have in front of you the report, but of course the report doesn't cover everything. You also need to read A, B and C. That too would have made this a non-point, but none of those things have happened. The important thing then is that the decision maker reading this report as the reasonable reader and mindful of the public statements that surround it would have understood this was giving them what they needed.
But Mr. Wolf, just to understand where this point is going to, you're not running legitimate expectation anymore, are you? So where does this point take you?
Well, in a sense, it's an error of fact, because the decision maker was quite properly making a fresh decision about the future of HS2, in the context of which they needed to balance all the various considerations, of which environmental harms was one of the considerations, no dispute about that. And in that context, they needed to understand the nature of and scope of the material they were being provided with. Now, we are not saying it at any particular level of granularity, as the Divisional Court seemed to think they needed to have X, Y, and Z. The point is that they needed to properly understand what they were being provided with.
Well, are you, sorry to interrupt, but just to be clear, are you submitting that the Minister must be taken not to have been aware of the preceding, to use your word, appraisal?
No, absolutely not, my lord. So can I just pause at one point?
Yes.
What we see is that, not to disagree with my lord, but what we see in a moment is that the decision wasn't actually taken by the Minister, it was taken by the whole Cabinet. And that puts a different flavour on the analysis. I'll come to that point in a moment.
All right.
We absolutely know that the Minister knew of the previous process. Indeed, you've just seen a paragraph that explained that. But knowing of the previous process is all the different from knowing whether you need to look back at that material, learn about it, in the case of the Prime Minister who wasn't an MP at the time, or refresh your memory if you had been an MP at the time, for the purpose of this decision. Being aware of the existence of other material doesn't in any sense translate into some understanding or instruction to look at that material, let alone some process of, if you like, osmosis by which you're taken to have brought it to mind for the purpose of this decision. And I'll show you a decision of this court in a case called Hunt, which deals with that in the context of a decision by a local authority, which has a similar complexion to it. So the issue, to answer the question raised by my Lord Justice Haddon-Cave, is the error, the misunderstanding, call it an error of fact if you like, on the part of the decision maker as to the information that they were provided with for the purpose of making this decision. And if the court is satisfied, of course, if the court is satisfied that the decision maker, and that means all the members of the Cabinet, as I'll show you in a moment, fully realised that this was incomplete, and therefore that they needed to look elsewhere, and that they then did look elsewhere, and got the necessary complete picture, then this point would fall away. But there is absolutely no evidence to support any of those things. And you'll see in a few moments the lengths to which the applicant has gone to try and tease out from the respondents information about what it was the decision makers were actually told, precisely in order to try and understand the respondent submission, which is, don't worry, they not only knew about the process, but they can be taken to have had that information in mind. Well, we can see that submission from the Secretary of State, put very carefully. If you look at paragraph, for example, paragraph 34,
Yes.
no arguable basis. So if I start at 33, they say this, 4 lines down in 33, it would have been obvious to the first respondent, can I just pause for a second there, one needs to write in all the members of the Cabinet, get home the respondent needs to make good proposition for all the members of the Cabinet. It would be obvious to all the members of the Cabinet reading those paragraphs that if they wish to remind themselves of those impacts, how they've been assessed and measures to place them up, they needed to look at the published documents. And then at 34, the court should proceed on the basis that the existing evidence known to both the review, so be it, and all the Cabinet members included the products of the parliamentary procedures which led the enactment of the bill. In other words, you are being asked to proceed on the basis that all the members of the Cabinet knew to dig out and remind them or learn themselves about or learn about the 2013 environmental assessment. And there's absolutely nothing to suggest that they would have had any clue that they needed to do that. And I'll show you, as I say, how this fits within the decision of this court in Hunt.
Well, just before you do that, could I just ask you a follow-up question? You've taken us to various passages in the report. Is there anything in the report that positively indicates that the environmental appraisal, if we want to use that word, contained in it, stands in place of the preceding environmental impact assessment?
There's nothing that links the two explicitly in that way, but what there is, and I've shown you the earlier materials and the report itself, it is the propositions leading up to it, that it should consider all the evidence and report to enable the decision maker to decide, not that it should do some partial exercise, partial in a sense of only looking at part of the information, but also the way in which the report presents itself as providing the decision maker with the information on the basis of which to do that. Now, as I say, all of this would have fallen away if the report had said, we are only giving you a corner of the information, you need to look elsewhere. So that's why we have to invite the court to look at this as the reasonable reader would do, and also mindful of the contextual information around the terms of reference and the announcement and so on, and say, what impression, what understanding would the reader have had? Would they have thought to themselves, I need to go and dust off the files from the archives to look at that information? Absolutely not, we say.
Right. I mean, are you submitting to us that it's implicit, though not explicit, implicit in the report, that it did, by way of environmental appraisal, stand in place of and effectively superseding the environmental impact assessment that had gone before?
Well, I do, but I don't need to go that far. Let me just unpack that if I may.
All right.
I do say that. Obviously, it is not substituting for 50 volumes of Lever Arch files. In the same way, it's not substituting for many thousands of pages, no doubt, of appraisals around other aspects of the project, around the operation of trains or the operation of finance or whatever. It specifically identifies itself as a report on the key issues. But it is implicitly, in my submission, providing the reader with the understanding that it gives them the balanced picture. It gives them the information in the round which they need to have in order to make this decision.
To what extent do we need to take into account that we're not dealing with a counsel of perfection here? The terms of reference were agreed, I think, on the 29th of August. Evidence was collected literally in a month, which everybody knows is an extraordinary, or rather, evidence was reviewed during the month. During that period, I think they received very detailed submissions from many individuals, and we've drawn our attention to those. And then the report was expected in the autumn, so let us say November time. This was I've used the vernacular, a quick and dirty review to inform a governmental decision. Now, I don't think we've all seen these documents as effectively your reasonable person was a reasonable political decision maker here. We weren't dealing with the public, we were dealing with a document addressed to whether it's the minister, or the prime minister, or the cabinet. It's a political decision maker. Do we have to take that into account when measuring the innate limitations of what could be achieved in such a report?
Well, of course you take into account the context of it, absolutely, that must be right. Quick and dirty, though, bearing in mind that this is a decision about a very substantial project, so the timescale can't be a license to cut corners, because this is a very important on-any-view decision, and the decision-making cabinet members are then making that decision on the basis of the information they're given, and they need to have a proper understanding of its nature and scope. If they had been given the health warning or the caveat that said this is incomplete in relation to environmental harms, then I wouldn't be making these submissions. But they weren't given any such caveat. Quite the contrary, they were given the impression, well, implicit if you like, that this was providing the information they needed to make this decision. And to look at the quick and dirty point, whatever the time scale, what you've seen is the sort of information that was provided to the review by some environmentally concerned contributors, which provided, in fairly high level and pithy terms, an outline summary of some of those environmental concerns. So the quick and dirty would have been no difficulty at all for the report to say, in the sort of level of detail that is set out in those submissions, here is the range and scope of the environmental harms. Or, Minister, you should really read the Wildlife Trust document or the Children's Society document to get an position. So there can't be any excuse for not drawing that information together, because to some extent, in relation to the NGO submissions, the review process was a bit spoon-fed. They weren't being asked to go back to bundles of documents from many years ago to do that exercise. But of course, and just to remind the court again, the minister in setting this process up with the terms of reference had asked them to examine all the existing evidence, and they had said they would do that. So limitations.
Isn't that part of the problem? That if you're asking someone to review all the existing evidence, which is container force, vast amount of information, and you're giving them a month, and then expecting a report in autumn, then there's an innate limitation. And when I use the expression quick and dirty, I'm not using it pejoratively. It's just the nature of the beast. It was quick and intense with a substantial team to inform a political decision. I understand the point you're making. You could say, well, given those limitations, it was almost more important for the author to actually highlight the limitations of what was in the report.
Well, yes, and in terms of timescale, the report was initiated in August and then published in February. So what we know is there was an initial phase, and then there was a lot of further work done on it. So it's not a month period. I'm not quibbling with my lord about the detail of that. But I think, as you say, my lord, what matters here is not so much the benefit of hindsight, standing back, understanding of the situation. It's the understanding that the decision maker would have had about the information they were being given. Whatever adjectives, quick and dirty or comprehensive, the other end of the spectrum one was to use, did they understand what they were being told when it came to environmental harms? And our submission simply is, no, they didn't. Their impression, use the word implicit if you like, is that they were being given sufficient to cover that off. And there's no dispute that they weren't. What's said to you by the respondent is, you have to assume that they all, A, knew that they needed to look back at the environmental assessment, and B, that they did that. And those are steps too far in our submission. But also, the other thing I was just going to show you in the review document itself, is at page 206 in your bundle. This is the section headed Economic Assessment of HS2. And quick and dirty or not in terms of the review, there's a lot of analysis and thought gone into this section. And it leads one, let me just show you a couple of paragraphs. Page 211, first off. This is the benefit cost ratio calculation. And at 11.13, the reader is told this: the full extent of HS2's environmental and social impact is not captured in the benefit cost ratio. So the reader is told that the environment is not in this financial calculation, but implicitly that they need to take those things into account, and that's slightly said in the rest of that paragraph. That proposition is interesting in the light of some evidence I'll take you to from the respondent in a moment. Then on 213, that point is made again in conclusion 51, impacts not currently quantified. And just to get a sense for the court of the way in which the case for this project had shifted, if we look at table 11.2, the 2017 economic case, if we look at rows 6 and 7, they are the benefit cost ratio in billions of pounds 2015 prices in two scenarios, and in one instance it's a 1.9 benefit cost ratio, and in the other it's a 2.3, not taking into account environmental and other impacts, obviously. If we then flip over the next page, 214, conclusion 52, we see there that the net economic cost of the transport budget as valued has increased from 40 billion to between 62 and 69 billion. So the cost has gone up enormously in just a couple of years, and that then feeds into page 215, rows, another table, table 11.3, row 6 and row 7, again, the benefit cost ratio in two different scenarios, and now we've got two different scenarios on capital cost. and if we look at the benefit cost ratio, that has shifted from 1.9 or 2.3, depending on what you're looking at, to between 1.1 and 1.5. So the non-environmentally including benefit cost ratio has dramatically reduced. So this project is much less attractive, even in pure finance terms, before you look at the environmental impacts. And so in that context, we say all the more important, well, that's rather put the other way around, that illustrates the importance of the decision maker having a proper understanding of the things that are not included in that computation to decide whether the project should still go ahead. And that gives you a sense of the way in which things have changed in that 2 or so year period. That then also was the OKB review report itself, and that led to the Prime Minister's announcement, which you have in core bundle page 140 at start, but 143 is the passage of his statement which reports the elements of it. So 143, text of the speech in effect, the relevant bit starts 4 sections down. When it comes to advocating HS2, about 6 or 8 lines down, the Prime Minister uses the following words, which the respondent relies on, I think: leaves no doubt about the clinching case for high-speed rail, but that those words are or were relied on by the respondent in a Section 31 type argument. But I'm not sure if that is now proceeded with in the light of what the respondent says about the balanced nature of it in the way they resisted Mr. Short's evidence. 2 or 3 entries further down that page, you then see an entry which says this: passengers arriving at Birmingham Airport will be able to get to central London by train in 38 minutes. So what that is telling the public is that one of the claimed benefits of this process is an enhanced access to airports. Now, none of that information is part of the greenhouse gas assessments of the project itself. Anyway, you then have over the page 4 lines down on page 144. So today, Mr. Speaker, the Cabinet has given high-speed rail the green light. Well, as we then have, and I just want to show you a few elements of it, the pre-action correspondence, in the course of which the claimant attempted to get to the bottom of, to understand the basis of the decision, and the reason the claimant wanted to do that, and it was reinforced, as you'll see in a moment, by the respondent's response to the claim, was because the claimant, the applicant, was fully aware that there might be other documents than the report that were looked at by the decision maker that would have made clear to the decision maker what else they needed to look at in environmental terms, for example, or made clear to the decision maker the full greenhouse gas implications of the project. So we were fully aware, that applicants and his legal team, that there could at any point be a killer document that came out of the Cabinet Office or whoever it was, his archives, that made either or both of these points go away. So the claimant wanted to make sure that he understood those positions before proceeding. Before I look at those, can I just look at the legal propositions that underpin that concern?
Right, just pausing, sorry, let's just clear the deck, shall we? Can we put the materials away for the moment? If you're going to look at legal propositions,
of course.
Do we need to have them open in front of us at the moment?
I need to show you at least one authority.
Yeah, but then we don't need the 2 bundles, the core and supplementary bundles. Right.
Apologies.
No, that's fine. It's just handling the paper. Right, so we'll have the authorities bundle ready.
So, my lords, you have in the bundle a number of authorities, and I won't round you through them, which all go to the proposition that a decision maker only knows what the decision maker actually knows, and they are not taken to know what, for example, their advisors or colleagues know. You have that put perhaps most pithily in tab 6. It's page 66 of the PDF, those who use the PDF, in a decision called Bracking.
Yes.
This court. But what the court here is doing is just summarising a point which is of general application. it's in paragraph 26.3,
Thank you.
in Lord Justice McComb's summary of principles relating to the PSED, but the point is the same here. With relevant duties on the minister or other decision maker personally, what matters is what he or she took into account, what he or she knew. Thus, the minister can't be taken to know what his or her officials knew or might have been in the minds of officials in proffering their advice. And that's a reference then back to the National Association case, which you have in tab 14. And that principle was applied, tab 13, you've got a copy of the decision in the Kohler case, Divisional Court including the Lord Justice Lindblom, and without enunciating it in quite that way, that's exactly the principle that the court applied there, which is that decision makers only know what decision makers actually know, and that the court will interrogate the evidence to understand that proposition.
Did you have a particular passage in mind in Kohler?
In Kohler, it's tab 13, and it's paragraph 60, and then 65 to 68.
Thank you.
So that's around page 158 in the PDF,
Yeah.
where my lord would have had submissions from me on those legal points.
Yes.
Didn't feel the need to set out the legal propositions, but nonetheless applied them.
Right. Thank you.
And you have a summary of those, and it's helpful in tab 17, which is Capital Stevenson. You've seen that already, Mr. Justice Dove. His paragraphs 36 to 40 summarises some of those cases and some of those principles. The case, though, that I want to look at in a little bit more detail is a case called Hunt, which is at tab 18, PDF page 279.
Yes.
There are several issues in this case. We are concerned with whether the local authority have discharged the public sector equality duty in making a particular budget decision. Just to lay the foundations factually of this, in order to discharge the public sector equality duty, or as part of that, the council have produced an equality impact assessment, a document that assessed the impacts of this proposal. And what the court was here concerned with, and you'll see that the High Court went one way and the Court of Appeal went the other, was whether the members of the decision-making council could be taken to have read that equality impact assessment because, so the judge found, they needed to have done so. So the operative factual question was, could the court take it from the information that the members of the council, all of them, had read the equality impact assessment? And there's some important steps on the way to that, but that's the summary. So you have within the PDF page 390 or paragraph 32. It must be 290, I think I've given you a wrong reference. It's PDF 290, I think. It's paragraph 32, yeah.
Right.
So paragraph 32, PDF 290, introduces the equality impact assessment. And we then, in a moment, we see reference to a summary of the equality impact assessment, but for now, it's the equality impact assessment. Then on page 46, sorry, paragraph 46, I'm sorry. This was the meeting of the full council, the 21st of February meeting of the full council, which made the decision. And we are told what papers the council had before, the council members had before them, is paragraph 46. And about 6 or 7 lines down, there's this, not in dispute, that each member must be assumed to have respected that commendation, in other words, read the papers, and read all the agenda papers provided to them. So we can assume, we have as it were, a legal assumption that decision-making individuals read the papers that are given to them for that purpose. Then it says this: those papers included an officer's report recommending approval and background documents, one of which was ... Appendix 6, which included the summary of the EIAs. So for the purposes of their meeting, the members of the council were given an Appendix 6 summary of the EIAs. But they weren't given the full EIA. We then, at paragraph 50, the Court of Appeal refers to the evidence of the lead counsellor on this topic, saying this: finally, the court should refer to Councillor Lake's evidence, to which the judge attached some importance. He was a member of the Executive Committee, and his portfolio of responsibilities included responsibility for the Council's approach to equality. It was he who, at the meeting of the 7th of February, suggested that members should, ahead of the full Council meeting, look at the EIAs themselves. So what we here have is an actual indication that members should look at the full EIAs coming from the councillor. So this, in his witness statement, if I can confirm, I was aware of the potential impacts of the proposals related to youth services. My awareness arose from a number of sources, including the EIAs, which I read in full, and addresses made at the council meeting by members of the public. So what we have here is specific evidence from one councillor that he had read the EIA. And what's important, and we'll see this in a moment, is that the Court of Appeal wasn't prepared to generalise from that to say, well, other members would also have read the EIA. Then we have the judge's judgment, and at 58 we see the way the judge approached it. The second, so this is then reference to the Court of Appeal first and then the judge's judgment. The second ground of Mr Hunt's challenge was that the council members present at the meeting did not have due regard to PSED before resolving the budget. The judge summarised what members had been provided with, saying that since January 2011, including those of 2012, they had no more than a summary of them. They did, however, know of their existence and have access to them. So this is an example of the decision-making councillors knowing of the existence of and having access to those additional documents. That's parallel to the situation here. No doubt that decision-making and cabinet members would have known of the existence of other documents. Then we have what the judge said, paragraph 90 of the indented quote. Let me take stock at this stage, said the judge. The members have been provided with or had access to all the documentation which officers have produced and which considered the relationship between the PSED and the proposed expenditure cuts. In my judgment, it's reasonable to infer that the members familiarised themselves with all the information contained within the documents which they were sent and to which they had access. And it's those extra words that matter. I say this for this reason. The decision whether or not to approve the revenue budget was obviously a very important one. In the absence of any evidence to the contrary, it's proper to infer that persons taking the decision would do all they reasonably could to inform themselves of all the features which were relevant to the decision to be made. Councillor Lake says in terms that he did, and I would expect that all responsible councillors would approach the meeting in just the same way. But that was the way the judge proceeded, and then he reached a conclusion. You have his conclusion on 92. I've reached a conclusion on the balance of probabilities that members familiarised themselves. So that was the way that the judge dealt with it. Court of Appeal then at 61, first of all says, it's implicit in the judge's conclusion that he considered the members would only have discharged the PSED if they'd read the EIAs, and that if they merely read the summary, they would not have discharged the PSED. So that's analogous to the situation here. And then we then go to paragraph 80, jumping over the Court of Appeal's analysis on other points. Section starts at 78, but picking it up at 80. In our judgment, therefore, and since it was not open to Mr Hunt to challenge the adequacy of the EIAs themselves, the only remaining question on this aspect of the appeal is whether the judge was right to find, as we understand him to have done, that the council members have all read the relevant EIA itself. If he was correct on that, there's nothing left of Mr Hunt's appeal on the PSED issue. Was he correct? So what was the appropriate inference from that set of circumstances? And then the next passage, starting at paragraph 83, is where they then explain the position. For our part, and again with respect, we are unable to agree with the judge that the inference he draws was one that was available in the evidence. We have no difficulty, nor was the contrary suggested, in accepting that if council members are provided with a particular set of materials for the purpose of the meeting, they can, absent positive evidence to the contrary effect, be taken to have read all such materials, and also to have read any additional materials to which they were expressly referred, and to which they were told they needed to have regard for the purpose of the meeting. If, for example, they'd been told that a key document was too bulky and too expensive to copy and circulate, but was available at a given website address, and they were further told in appropriate terms that this document was required reading for the purpose of the meeting, we consider they must be taken to have accessed it and read it. In the present case, however, we do not interpret the language of Appendix 6 as indicating to council members any need or requirement to read the EIAs themselves. Whilst they were told how to access the EIAs, they were not told, either expressly or impliedly, that they must or should consider them before the meeting. The fact they were summarised in Appendix 6 itself suggests that a reference to documents themselves was not essential. Why bother to summarise a document which must anyway be read in full? Moreover, the terms of paragraph 12 of the officer's report to members suggested in Appendix 6 told the members all they needed to know for PSED purposes. And then they over the page deal with Councillor Lake, paragraph 85, just below letter B. We do not, however, regard Councillor Lake's evidence about what he did as providing any indication as to what all the other councillors did or like to have done. Councillor Lake was in a special position as portfolio responsibilities included the council approach to political issues, and he explained that he received training in relation to decision making on PSED. Fairly obvious that he would have read the EIAs. But we say that those principles, that approach applies exactly here. What the Cabinet in the end was provided with was a summary document in the Oakerby Review report, which on its face summarised the issues they needed to make a decision on the basis of. It told them that there were other documents out there, or there was another process out there, but it in no way suggested to them that they needed to look at those other documents. And indeed, picking up the point from the Hunt analysis, the very fact that the report proceeded in the way that it did, particularly when read in the context of the materials which set it all up, would have given them the impression that they didn't need to look beyond the report. They were being given a report which had been set up to provide the information that was needed to make this decision, following an appraisal of all the existing evidence. So the impression they would have had is, I read the report, that will be the basis on which I proceed, and that's a sufficient basis. But what we know is that that wasn't a sufficient basis, and therein lies the difficulty. Now, as I say, I've said several times, were there evidence from the respondents' files or whatever of any contrary indication being given to the reader, to the decision-making cabinet members, then all of this would of course drop away. But there is nothing of that kind in any shape or form. So, as I say, the error here, the legal error, is in the understanding on the part of the decision-making cabinet members as to what was being provided to them, and that is not answered by the information we now have from the respondent to say, well, there was other stuff as well, because the other stuff as well has been completely unparticularised. And it's that point which I was about to take you to, which is the claimants' or the applicants' attempts to try and understand that material in order to see whether indeed this point was or was not agreed on. And also, I need to show you that material in a little bit of detail. I'll come to it in a second. I anticipate a question coming up.
So can I just make sure I've understood your submission? Your submission, I think, would lead to this, that if a summary provided to a decision maker is accurate and fair, then there is no need to look at the underlying document.
Yes, I think that must be right. That must be right. The issue here, though, the reason I'm hesitating is I'm not sure quite how that arises here, because, as I think I mentioned earlier on in my submissions, there's no suggestion here that the paragraphs within the review report provided inaccurate, but it provided a proper basis for the decision making here. That's why the respondent repeatedly says, well, the cabinet members must be taken to know all the previous stuff. There's no suggestion. It's a bit like the relationship between the EIA and Appendix 6 in Mr. Hunt's case. It was something of a summary, but it's not suggested to provide the answer. I may have misunderstood the
but it wasn't entirely clear from Hunt whether or not it was being said that the summary was a materially inaccurate summary of the underlying EIA itself.
I don't think it was said to be materially inaccurate. It was just insufficient. It didn't cover the ground.
Right. But
There's nothing in there that said it was. There was never any. What's the right word? There was never any argument to the effect that its analysis of the equality impacts misled them. It was a pure sufficiency question, as it is here, if that makes sense.
understood.
Mr. Wolfe, could you just summarise for us, dictate, what is the proposition that you say we should derive from Hunt?
So the proposition is in the court's approach to the evidence that's considered by a decision maker which comprises a number of people, whether that's a council committee or council, full council as it was in Hunt, or here the cabinet, which is that the court is concerned with what all of the members know and not just what you might call the lead member, the councillor Lake or the grant chapters, depending on where it may be.
So you're supposed to be dictating this. Okay.
I'm sorry.
Well, just start. If you just pause and start again, because I'm sure it would help all of us if we had a crisp formulation of the point that you seek to take from Hunt and the other authorities that you've touched on.
So in terms of the other authorities, it's that the decision maker only knows what the decision maker actually knows and is not taken to know what others know.
Yes.
And then in the context of Hunt,
Yes.
First point, with a multi-headed decision maker, the court is concerned with what all of them knew, not with what any one of them knew. Point one. Secondly, they can be taken to have read what is provided for them for the purposes of the decision making, or things outside that they are told they need to read, but they can't be taken, absent positive evidence obviously, to have read or therefore be aware of the contents of other materials, even if they know the existence of those other materials.
Yes, aware of the content, isn't it, of other materials? You're
That's
saying.
right. So knowing that an EIA was out there, as these councils were told, knowing that there was other information out there in environmental terms, as the reader of the report will know, is not an answer. You can't go from that to say, well, therefore, they read that material, or therefore they, if they'd seen it before, drew it to their attention. And my lords, these propositions are entirely at ease with, if you in Mr. Short's materials, I imagine you might have that as a separate clip.
Yeah.
He has provided the court with an extract from the Cabinet Manual.
Yes. Do you want us to look at those materials?
If you wouldn't mind just turning to one page of it.
Yes.
It's page TWS1, I believe 86. I'll just jump straight in if I may.
Right.
Paragraphs 428 to 430, particular 430, papers and presentations for Cabinet and Cabinet Committee should include any information that is needed for ministers to make an informed decision. They should be concise and set out the benefits, disadvantages and risks associated with the proposed policy. Any decisions that need to be made by ministers should be clear. Papers should explain any public expenditure implications, where a paper is not, and then there's the procedural stuff. So that requirement, and we don't place any legal force on it, we simply say, well, that's entirely consistent with what the court would expect to see Hunt. The decision maker needs to be provided with the information they need to see the pros and cons, risks and advantages, whatever you may call it, of the paperwork, and that's set out in the Cabinet Manual. And as I say, had we been provided with, or had the court been provided with some document that had been provided to the Cabinet for this process to say to them, you need to look beyond the Oakerby report for environmental information, then the point would go away, just as had the papers for the council in the Hunt case told councillors, well, actually, you do need to click on the link and download the EIA. And in terms of the court's approach to evidence, we've also drawn the court's attention to the old decision in Paris. We've got that in tab 16, it's PDF page 227.
Right, just a sec. We're putting the cabinet manual away.
Put the cabinet manual away, yes, thank you very much. Thank you for that.
All right, and we're now, sorry, at Powys.
Legal materials tab 17.
Thank you.
Paris.
Yes. Is it 17? I'm not sure. That's
16, I'm sorry, 16.
Yeah.
16.
All right, thank you.
Page 595G of the law report, page 238 of the PDF.
Sorry, I'm so sorry. The page number in the print.
In the law report 595.
Thank you so much. Yes.
Letter G, this is the classic formulation of the fresh evidence point, and the first limb of the fresh evidence in judicial review point is between G and H. The court can receive evidence to show what material was before the minister or inferior tribunal. That is because, consistent with what I've taken you to in all these authorities, the court is concerned to ascertain exactly what was before and taken into account by the decision maker. That really is the elementary stepping stone on the way to a Wednesbury type analysis. If you've got to take into account the relevant and ignore the irrelevant, the court has to know what you've taken into account. So here, the relevance of that here is that it would have been entirely open to the respondents to put in evidence as to what it was that the cabinet members actually had, whether it was more environmental information or more signposting information, if I can put it that way, to disabuse them of the impression they've got from the Oakerby Review report and the other materials. What we've had, and I'm about to show you a flavour of this, is a series of teasers, frankly teasers, from the respondents on that point.
And what do you say is the flavour that they would have got from the Oakerby report?
I've just seen that a message came up that said Lord Justice Green has left the meeting.
Ah, let's pause then. Let's pause for a second. He will no doubt be attempting to rejoin if he has. Just wait for a moment. If it's not clear that he's rejoined, and then we can establish exactly where he left us. I think what we might do is stop. Ah, good. Now, can you assist us?
It's really for about a minute, that's all.
Right. Now, had Mr. Wolfe taken us to Paris?
He was just doing so, and I caught the first part of that, so I took note.
All right. I'm so sorry, Mr. Wolfe. This sort of thing is liable to happen from time to time. We take care to ensure that nothing that you've said is going to be missed. So perhaps in an excess of caution, take us all the way back to Paris. You were on page, if we're working off the law report, page 595, though I apprehend Lord Justice Green has the electronic version of it. And then just...
My video isn't working, please don't worry about that, I can hear properly.
Right. Well, if you
So
just...
I was on page 238 of the PDF, just to remind the court of the basis on which in judicial review the court receives fresh evidence. It includes evidence as to the materials that were before the decision maker. That is because the court is concerned to identify the basis on which the decision maker made their decision. And the relevance of that here is, in a sense, part of our riposte to the respondents' proposition that they say that the decision makers can be taken to have all this additional information. We say, and in other words, there was no deficit of information. We say, in effect, and I'll show you this in a second, please then provide the information, and Powys allows you to put it into court. And what they've given us, and I'm about to look at some of that, it is a flavour of some of the documents, not even a flavour, just a description of some of the documents that were provided to ministers and cabinet members, but no detail, and certainly nothing that would respond to, and I think this is the point we've just got to in the live hearing, nothing that would respond to the impression they would have got from the Oakerview report. And then Lord Justice Haddon-Cave asked me to remind the court of what impression we say the reader would have got from the Oakerview report. Is that, have I kind of rewound the clock sufficiently?
I got all of that. I didn't get what my Lord Justice Haddon-Cave thought.
Okay.
So thank you very much. That's very useful.
All right.
So just to pick up on the last bit,
Thank you.
the impression really is the point that I was canvassing a few minutes ago. The impression being that the Oakerview report gave them the information they needed in order to make the balanced decision looking at the pros and cons of the project. When, as I've explained, it didn't give them that impression, it did give that impression, it didn't give them that information. And the respondent doesn't claim that it did give them that information. That's the other important bit of the jigsaw puzzle. The respondent has never said, and quite rightly not, that the information in the Oakerview report was sufficient in terms of environmental harms for this decision to be taken. Their answer at every stage, that's why I took you to paragraph 34 of the skeleton, is you have to take it that the decision makers were not just aware of, the fact of, but the content of other assessments. And it's that last bit where Hunt and the other cases are fatal to the respondent's submissions. Well, so we put away the legal materials bundle and just go back then to the supplementary bundle.
Right. Thank you.
There are two themes in this correspondence, this short clip correspondence I'm going to show you. One relates to the identity of the decision maker, and the other relates to the information available to the decision maker, or known to the decision maker. And you will see in this correspondence that the claimant was pursuing those 2 points precisely in order to get to the bottom of the thing we've been canvassing. Exactly what did the decision maker have beyond the Oakerview review report, which might have led them to have a different impression. So the 2 questions being asked are, who was the decision maker and what did they have before them? And the pre-action correspondence starts then at page 246. That letter says in terms, 3 paragraphs down, we write in relation to the 11th of February decision taken by the Prime Minister and Secretary of State for Transport. And then 2 lines further down, if you disagree with our understanding of characterisation of the factual situation, please explain clearly the nature and basis of your disagreement. Now, just to put a marker down, at no point until the evidence on the 30th of June did the respondent disabuse the claimant, the applicant, of his understanding as to who had taken the decision. Now, this pre-action letter, 28th of February, then sets out on page 247 details of the matter being challenged, section E, the Prime Minister's decision, ... You'll see in the next letter that the respondent responds to this by saying, well, actually, the proper respondent is the Secretary of State. So the claimant then focuses attention on the Secretary of State, and you then see evidence put in by the respondents as to what the Secretary of State knew. Now, all of that falls away, or is only part of the picture, once we are told in due course that this was a decision by the Cabinet. This is directly analogous to the focus on Councillor Lake, as opposed to the full council. The court is not, in the end, concerned with what the Secretary of State knew, or had read, or was told, just as the court wasn't in the end concerned with what Councillor Lake knew, or had read, or was told. They are in a special position, because they are not the decision maker.
Just pause. Where are we told in terms that it was the Cabinet's decision?
We're only told that, and when we get to sorry, I'll find the right reference in a second. It's the witness evidence from the witness evidence is sorry, my note was letting me down.
Do you want to come back to that?
I'll come back to it if I may in the order we come to the documents. I'm sorry, I just can't.
All right,
really see
yes,
my-
all right. Well, no, do come back to it.
My lord, I think you'll find it in paragraph 21 of Mr. Stewart's evidence.
That's very helpful, thank you, yes.
The first witness statement of Paul Stewart, which is tab 3 in the respondents bundle.
I'm grateful for this one.
And it's paragraph, sorry Mr Mould, paragraph
I believe it's paragraph 21,
21.
first sentence.
Yeah.
I think it's in the Prime Minister's statement to Parliament, which talks about the Cabinet has given high-speed rail the green signal. It's in a line that you read to us earlier. It's on C144, it's recorded.
Yes, so that was part of the political announcement. Then, as I say, the pre-action correspondence, 247, you've seen that letter. Sorry, this is like before 247. 246 is the pre-action letter we looked at a second ago. 247 refers to the Prime Minister's decision, and then that letter sets out, in a pre-action way, the legal concerns. And at page 260, so 257, it makes the point that I've been making about the basis on which the decision maker proceeded. It makes that point by reference to the Prime Minister, paragraphs 30 and 31. And then on page 260, under details of information sought, it asks about the information specifically considered or known to the Prime Minister and Secretary of State for the purpose of that decision making, because as it's made clear, that's what we need to know about. The response to that letter starts at 3. The point I draw from this is that at no point does the respondent say, you've got this wrong. It wasn't either the Prime Minister's decision or the Secretary of State's decision or a joint decision or possibly a decision involving the Chancellor, because he too is mentioned in various places. Paragraph 5 on 310 specifically refers in terms to the Prime Minister's decision. We never disabused or the understanding as to what was known. Then paragraph 11, this was the defendant's initial response, and the line hasn't really changed. Paragraph 11 on page 311.
Sorry, 311.
It is and has always been clear that the Oakley review and its recommendations would need to be read in the context of the very substantial work and consideration that had previously been given to the project. I'm just pausing for a second there. There is no claim there or anywhere else that the Oakley review provided sufficient information. The proposition is that it was always clear you needed to read the other information. And we say that is the flawed proposition. That proposition simply cannot be made good on the evidence. So the respondent can neither make good the proposition that it was clear you needed to read elsewhere, nor make good the proposition that all of the Cabinet members in fact did so by accident or luck, in order to provide themselves the information they needed for the overall when and how decision. Then in response to the documents question, this is page 312, paragraph 20, in response to the question, please can we have the documents, as set out in paragraph 15 above, the government intends to publish a more detailed response to the Oakley review in due course. Now, as far as we know, that has never been done, and certainly nothing has been done which puts in the public domain the information that the claimant was seeking. Then at 314, a further repeat request for documents. And at 317, if you're not going to give us the documents, at least give us a list of the documents. And then at 322, the answer to those two letters, we are considering your request in detail and intend to respond to you in due course. And we've never had a response to that letter. never had a response to that letter. It might be said that that was overtaken by events, because we then had the hearing before the Divisional Court, and at page 343, you have the witness statement of Mr. Haslam, which was prepared and provided shortly before the Divisional Court hearing. He says at 344, the purpose of this statement is to provide information regarding the documentation the Secretary of State of Transport had before him prior to government making its decision to proceed with HS2. And then he told the Divisional Court that not only did the Secretary of State have the Ogilvy report and a dissenting report, he also had, and this is paragraph 7, other relevant arguments and evidence surrounding the case for HS2. No claim there that there was anything.
My friend would read on to the end, just because it identifies a consistent theme as to who made the decision.
This advice included material from the existing published evidence base and other unpublished evidence, some which we made.
Words, I do apologise. My Lord, sorry, just out of critical words.
Okay, I can confirm that the advice the Secretary of State of Transport was provided that contained an analysis of the Ogilvy Review report and the Berkeley dissenting report, alongside other relevant arguments and evidence surrounding the case for HS2 to support the government's decision-making during the period before 11th of February 2020. This advice included material from the existing published evidence base and other unpublished evidence, some of which we made public in a forthcoming Phase 1 full business case. Now, that's the first teaser, or perhaps the second teaser. We have never had any more detail than that level of detail. And most particularly, we've never had anything, let alone by reference to all the members of the Cabinet, which explains that they had necessary extracts from early environmental information. That would be one option. Or alternatively, something which told them in terms that they needed to look beyond the Ogilvy Review report for that information. So to be told that they had other things is merely a teaser. It doesn't answer the proposition. It doesn't provide a foundation for a response to the claim. Well, as I say, that was just before the Divisional Court, and I'll come back to the Divisional Court's judgment in due course. We then have, if I may, if I can then take you to our grounds of challenge, or I pick up some of the sort of aspects of the Divisional Court's decision.
All right. Can we let's just pause for a second.
Of course.
Obviously, you've got a good deal of ground to cover, but are we making good progress? Do you think?
I think so, because I've shown you pretty much all of the factual material I need to show you. There might be a little bit more, but not a great deal more, and it's really drawing that together with a little bit more law. That's the court.
That's fine. Thank you. Yes.
So, Lord, in terms then of round 2, I've already, in exchange with the court, made most of the running on this, I hope.
Yes.
That the simple problem was that the decision maker, we now know to be the Cabinet, would have proceeded on the basis of a misunderstanding, an error of fact, if you like, as to the nature of the information that was being given to them in the Ogilvy Review report, and in particular as to whether it provided a sufficient and proper basis for them to weigh the environmental harms in the balance, in the overall balance. Now, we are not asking the courts to second guess that balance, of course, and we are not making any point, contrary to what the Divisional Court seem to think, that says they needed to know any particular thing. What matters is was their understanding of the information before them. Now, that is also importantly seen in the context of the respondent's response. I've taken you through this already. The respondent does not claim, and never has claimed, that the report provided them with sufficient information. It's a bit like the EIA in the Hunt case. The summary was not enough. The respondent has repeatedly, and again I've shown you this at various points, said, but they can be taken to know of the prior process. Well, yes, we agree with that. And the content of it. Well, no, the court cannot go that far. That's the Hunt, that first instance error. Just because the reader would have known that there'd been a prior process, that doesn't provide a basis for the court to infer that State or more so Cabinet members went away and looked at those other materials or can be taken to know about them. So there is an absolutely unplugged gap in the information known to the Cabinet members, which they were not aware of, and it's the not aware of that matters. So their approach to weighing would have been on a flawed factual understanding of the position. And that really is, in one sense, the point in the round. And as I say, I showed you earlier on, paragraph 34 of the respondent's skeleton, where they invite the court to proceed on the basis that the decision maker, which must mean every member of the Cabinet, somehow knew the content of the product of the earlier process, and that's simply not, that's a step too far.
So without oversimplifying, and I don't seek to reduce it to this, but an essential point in this analysis is that they can be taken to have known, that's the members of the Cabinet who are making the decision, can be taken to have known of the existence of the environmental impact assessment that had gone before, but not of its content.
At least of the process. I think
The process.
I showed you the passage in the report which said that there has been a prior process. It didn't refer in terms to any aspect of it, so
Right.
we accept that they would have known the existence of the prior process.
Yeah, I just wanted to get it exactly right. That's the way you put it. They can be taken to have known of the existence of the prior process, but not the content of the environmental impact assessment itself.
Mr. Hall, can I just ask it? Does it make any difference to your analysis that the prior the prior process led to a formal decision of approval? So we're talking about two stages here. One, there was a culmination of the process leading to a decision. And now we're looking at a second stage of that process. In Hunt, it may well have been, or in other cases, you've simply got a single continuum leading to one decision at the end. So to what extent would that affect the Cabinet's view that they knew that the environmental matters had been approved beforehand?
My Lord, I think I hope I've got a reasonably straightforward answer to that, which is that the prior decision was akin to a planning commission, and it balanced the planning factors, as it were, to decide whether the planning permission should be granted. What we then have, some years later, depending on how you do the timeline, is a decision by the developer as to whether to proceed.
Yes.
And what the Cabinet's, or the Secretary of State set out to do, and what the Cabinet then did, was to take into account all the considerations, I'm summarising what was set out in the terms of reference and so on, to decide whether to proceed. So that was a fresh decision, mindful of the fact that, as it were, planning permission had been granted, but nonetheless a fresh decision looking at all the factors to decide whether to proceed. And the fact that it was all the factors is in a sense, common sense and obvious, because, as I showed you, some of the financial factors had changed quite dramatically. The benefit-cost ratio had shifted downwards quite significantly. So when the Cabinet then makes the decision as to whether to proceed, quite properly, and Lord Oakerby direct them in this direction, quite properly, they were looking at all of the pros and cons, absolutely the right thing to do. You couldn't park out of that, pull out of that, the earlier decision and saying we're making a decision on whether to proceed, but we're not taking into account the environmental factors. Now, that's not what they did, so we don't have to critique that. They approached it on the basis they were looking at the things in the round. And so in that process, just to know that the environmental impacts had been assessed is no answer. That's why I showed you, perhaps slightly tediously, those sections, for example, in the chapter dealing with cost-benefit ratios, that made clear that the cost-benefit ratio didn't include the environmental elements. It told the Cabinet members that the project was less financially advantageous in that evaluation, and effectively told them implicitly, if not explicitly, they needed to then look at those other factors in the round. The difficulty was that they were then not told that the information they were given was incomplete. So that's a long answer to my Lord's question.
So to come to the chase, your analysis, the two decisions that you rightly said, one was a planning permission type of decision, the next question is more rounded, is whether and is how to proceed. They're slightly different decisions in their nature, but that, I mean, if the prior decision on the environmental matters remains static and has been approved, the change in the nature of the decision doesn't alter that fact, but you say that...
No, and I think that's what I'm not agreeing with that, Lord. But the point is that when they come to make the second decision, whether to proceed in the light of changes over the last several years, they can't, as it were, take out of that calculation and say, well, the environment bit was assessed before, because it's not just that the environment bit was assessed, that's not the point. What matters is that they factor the environmental harms into their proper Wednesbury decision on the project overall. So they have to factor into account the cost-benefit ratio as one part of the picture, the environmental harms as another part of the picture, and no doubt other things as well as part of the picture. But what they can't do is to slice one bit off and say, well, that was assessed before, and then not know about the content of the outcome of that assessment, because that then is not, I mean, it's a very basic, we would say, Wednesbury proposition. Wednesbury proceeds on the basis that the decision maker makes a balanced decision on the basis of all the factors. One of those factors here was environmental impacts. That needed to be part of their decision. And that's not, as it were, contradicted by the Oaktree report or anybody else. It's agreed with. There's nothing in any of the documentation at the time which says we're taking this decision oblivious to environmental impacts because they were assessed before. You can't slice it out like that.
Would you accept that logically it's at least a relevant part of the context that there'd been an approval as part of the prior process? If there hadn't been that, then to ignore it would have been intolerable, plainly unacceptable. It's a less acute issue, given that there'd been a prior approval. I hear everything you say, I understand that. But in terms of on the spectrum of the scale of these sorts of cases, the fact there's been a prior approval would be something which the Cabinet could at least take into account.
Well, yes, in the sense that somebody has assessed these environmental impacts in the past, and they've done some mitigation proposals and all the rest of it. That is relevant contextually, if you like. But when we then come to make a decision, as government, as the developer, looking at cost-benefit ratios and so on, to decide whether this project should now be given the green light, to use the Prime Minister's words, all those things are in play and properly in play.
Yes, I understand.
And because the cost, just to go back to the cost-benefit ratio, the cost-benefit ratio is now not nearly as benevolent as before, and we have additional problems arising from greenhouse gases and the Paris understanding of that, and we have environmental harms. Those things all have to be put in the mix. And none of that's in dispute, none of that's controversial, I don't think.
But just following on from Lord Justice Green's point, looking at it in Wednesbury terms, could a reasonable assumption have been that since, as my Lord has just said, it was known that the EIA had been done and dusted, that there wasn't anything particularly significant that needed to be unearthed and reassessed at this second stage?
And I think that may be the EIA in no sense reached the conclusion that there would not be environmental impacts. It reached the conclusion there would be very substantial environmental impacts. Those impacts had to be weighed in the balance in the evaluation. It's not for a second the case that the EIA assessed all this and said it's all fine. It assessed it and said there are significant harms, and so the decision maker in deciding in 2020 whether to proceed then needs to know about those significant harms. Whether they were using 3-year-old assessment that had been used for a previous evaluation or not doesn't change that at all. That they are making, as the Secretary of State repeatedly said in Parliament and in published documents, a fresh decision on whether and if so how to proceed. Entirely proper decision, but it needs to be taken on a lawful basis.
But there were two processes, weren't there? The first process was what I'll crudely characterise as a merits-based consideration, if you like, the classic planning consideration of the project, weighing advantages and benefits on the one side, disadvantages and harm on the other. And that was the prior process. This process is a different process in its nature. It may be described as essentially a political process in which the government is deciding, having got the requisite approvals through the statutory process at the first stage, whether or not it would go ahead with the project, it being essentially a government project. It was akin to either a local authority whose own land was affected by a consent for development, or for that matter a private sector developer, deciding whether to go ahead. And that was the essential nature of this process that we're now concerned with, wasn't it?
Absolutely right, my lord. But that doesn't change that. Doesn't change the fact that that second decision is still a merits-based decision. It's still looking at the pros and cons. And if we look at all the materials I took you to, and I won't take you back to them, that was exactly what was announced to Parliament in August. That's exactly what the terms of reference set out. And that's exactly what the Oakerview report proceeded to, on the face of it, offer, was a merits evaluation, pros and cons.
Yes, but the merits evaluation in the political decision took place against the background or in the context of the prior planning process, if I can call it that, which had reached its own conclusion.
Absolutely, my lord, of course, and that's why we can't divorce the two. But what matters is that when you come to make the second decision, and that's why I showed you, perhaps tediously, the cost-benefit information, things have changed. So, however the balance was struck in 2017 against the more benevolent cost-benefit ratios, that is not an answer to how the balance is now struck against the less benevolent ones. You can't take the cost-benefit and say it is now less attractive, and we're going to divorce that somehow or isolate that from the environmental harms. In one sense, the environmental harms become all the more important in the evaluation second time round because the financial case is so much less attractive. So they are both merits decisions. I mean, one I suspect is planning focused, so that would be less focused on cost-benefit ratios. Second is explicitly focused on cost-benefit ratios and merits, and has to be therefore the full merits evaluation. Now, none of this is controversial, I don't think, because the report and the process and the Secretary of State and the respondent submissions all present it that way. None of them say this was somehow a different decision. It was presented as being, Secretary of State said, a blank piece of paper, open mind, we need to test all the evidence, that's exactly what was repeatedly said, to do the evaluation again. All the pros on one side, all the cons on the other, to restrike the balance. I don't think any of that's controversial. And none of that has changed. The issue then is what you do about environmental information in that calculation. And the problem the respondents have is that in that second stage evaluation, the respondents weren't provided with the necessary environmental information, but they were given the impression that they were. Mr. Mould, I think, wants to say something. I don't know. He's going to disbring me.
He was just smiling when you said this wasn't controversial. So we look forward to hearing his
look forward to hearing the
submissions.
controversy.
That's
absolutely fine.
All right. Well, you've made that point very clear, Mr. Wolfe.
So can I then pick up? I finally found my reference to Mr. Stewart. So if we just go to Mr. Stewart, if we would please. Mr. Stewart is in the respondent bundle. If we go to page 42, I think, of that bundle.
Yes.
You've seen a bit of this paragraph already. I just need to show you a little bit more.
Yes.
This is the paragraph, and it's the only paragraph really, 21 and 22, that tell you anything about what Cabinet members knew. The decision to proceed with HS2 following the LR was made by the Cabinet collectively, and then we're told there were a number of meetings and a number of briefings, and we're told a little bit about the overall scope of those briefings. And then the last 4 lines, it says, ministers were also advised that those who were critical of the HS2 project might take the view that some adverse impacts on the environment, such as impacts on ancient woodlands, impacts on noise, air quality and carbon, were not monetised in the cost-benefit appraisal. Now that's a very funny sentence, a very odd sentence, because the Oakerview Review report itself made clear that those things were not monetised in the cost-benefit appraisal. So if it's the case that Cabinet members were, as it were, told this is a critique by third parties, then the third parties were absolutely right in what they were saying. And it goes to the point I've just been illuminating the court with, which is the cost-benefit ratio has shifted in the intervening period. Therefore, the things that are not taken into account in that calculation have to be refactored in and refactored in properly. Well, then we have step 22, and this is picking up the greenhouse gas point.
Yeah.
Paragraph 22, 4 lines down, he says, I confirm that the briefings to ministers included advice that HS2 could help deliver the government's commitment to net zero. And we say that's fine as far as it goes, but it only told them part of the picture on greenhouse gases. So those essentially are the points we make in relation to ground 2. I won't unless you want me to at this stage, take you back to the Divisional Court. Our fundamental proposition in relation to the Divisional Court is that the Divisional Court didn't deal with those submissions, which were clearly our submissions before, that they approached it as if we were arguing, as it were, a sort of cartoon stroke Creed NZ type argument about a need to include certain information, or that the terms of reference were somehow deficient. But those were never our arguments, and I hope our pleadings made that clear. So the Divisional Court simply didn't deal with or give reasons for rejecting the submission that we were actually making, which is the one that I've remade before this court. Of course, the other thing about the Divisional Court's approach was that they too were proceeding on the understanding that the decision had been made by the Secretary of State, possibly Secretary of State and Prime Minister, but certainly Secretary of State, rather than any focus on the Cabinet. And at no stage did the respondent in its dealings with the Divisional Court disabuse the Divisional Court of that misunderstanding. Well, can I then pick up ground 3B, if I may, which is the climate change point?
Yeah.
Well, the kicking off point for this, if you can pull away the supplementary bundle and turn up the legal materials bundle, is in tab 15, obviously with due trepidation since two of the present court were two of the court in that case, the Plan B Heathrow case.
Yes.
To page 202 of the PDF. Yes, 202 of the PDF. The heading at the foot of the page is divorced from its text. So it carries on page 203, and it's paragraphs 184 and 185, which set out the part of the Paris context for this. And so what the court did there was to identify the way in which the Paris Agreement has shifted the ambition for greenhouse gas impacts from one set of temperature goals to another set of temperature goals, effectively a 2-degree aspiration to a 1.5-degree aspiration. And it had required things to be done by 2050. Those were the two themes that the court was identifying there. And as my Lords, Lord Justice Lindblom and Lord Justice Haddon-Cave may recall, the issue here, and it's picked up in 186, was that the Secretary of State simply hadn't had regard to those things. He had focused only on the domestic framework, which had not yet caught up with the Paris situation.
Yes.
You have then you have at 217, if you're working from the pages in your bundle, paragraphs 2, 3, 4 and following of the court's decision there, and in particular at 237 and 238, the first bit deals with the Secretary of State having not thought he had a discretion to take into account Paris. That was the first legal error. Then it says in 237, secondly, and in any event, if he had appreciated he had any discretion in the matter, we agree that the only reasonable view open to him was that the Paris Agreement was so obviously material that it had to be taken into account. And then the court explains the legal provenance of that proposition.
Yes.
Particularly over the page, as Lord Brown observed that the category, there can be some unincorporated international obligations that are so obviously material, they must be taken into account. The Paris Agreement fell into this category. And then the court explained quite properly that, of course, taking it into account didn't drive any result.
No.
We, of course, have exactly the same caveat in play here.
Yes.
But what we draw from that is the obvious materiality of the Paris Agreement. Now, in terms of where that argument then goes in front of this court, what the respondents say is, first of all, they say that only applies, and the court was only speaking in the specific statutory context of the Planning Act, and so it doesn't apply here. That's their first point.
Yeah.
And then their second point is, yes, but the Paris Agreement has now, in the relevant ways, been given effect to in the Climate Change Act, including in amendments to net zero and the carbon budgets.
Yes.
As for the first of those, I'll come back to them slightly in a moment, but as for the first of those in headline terms, we say that the court's decision is not in any way reasoned by reference to the particular statutory context. The evaluation arose in the context of the discretion which the Secretary of State had to take into account climate change matters and how he then exercised that discretion. Exactly the same is the case here. The Secretary of State had a discretion, he exercised it to take into account climate change matters, and the court is then concerned with how he did so. It does not matter that in the first one there was a statutory backdrop to that consideration, and in the second it was simply his election, as it were, to decide to look at climate change impacts. In both cases, Paris was obviously material. In other words, it doesn't matter how you get to the discretion, which the court was referring to in page 237, once you're in the discretion taking into account climate change impacts, it's obviously material to take into account Paris.
Yes, that's to say, irrespective of the statutory context to which your submissions were directed in
exactly right.
Plan B.
Exactly right. It doesn't matter how you got through the door of that discretion. Once you're through the door, then the position applies. I won't say more about that point. The second point, which is the point about Climate Change Act carbon budgets, or Climate Change Act and carbon, I will say a little bit about that if I may. Just before I introduce that though, can I just show you how this comes from Paris? Because just to deal with the respondent submission, even if we accept, and some people I know regard it as controversial, even if we accept that the Paris Agreement can and in due course will in principle be incorporated into carbon budgets, what that simply means in terms of the legal thinking is that those implementing measures then themselves also become obviously material. If Paris was obviously material to a decision like this, then once it's been domestically implemented, the domestic implementation is obviously material. Indeed, you might say it's even more obviously material because any argument about it unincorporated international law has now been washed through the system. So you will have seen how our argument is put on the basis that they either fail to take into account the obviously material Paris Agreement or the obviously material Climate Change Act carbon budgets, which in this regard implement Paris. In terms of the Paris bit of that, you have in Legal Materials Bundle tab 4, the Paris Agreement. If I can just ask you to turn that up briefly and go to Article 4.1.
Yes.
In order to achieve the long-term temperature goals set out in Article 2, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, ... and to undertake rapid reductions thereafter in accordance with best available science. The relevance of that, and you will see this explained slightly differently in a moment, is that this is not simply about what happens in 2050 or by 2050, it's what happens in the intervening years as well. And you'll see that because the UK's net zero target, which is part of the implementation of Paris, is focused on what our carbon emissions look like in the year 2050. As I'm about to show you, climate change and the temperature rises are concerned about, not my expression, cumulative emissions over time. So it matters what happens between now and 2050. I can show you that if I may. If you want to put aside that bundle and go to supplementary bundle tab, page 13.
Yes, just a second.
This is a report ahead of the point at which the UK amended its net zero target. So this is Climate Change Committee stuff. So to page 14, I'm sorry.
Yes.
This was the point at which the relevant statutory bodies and their assistants were advising on the amendment of the net zero target. So this is pre the summer of 2019.
So sorry, this is the sorry to interrupt you. This is the we don't have the cover of the document, do we?
You do at 13. So this is an advisory group to the statutory committee.
Right, so that's the
But
cover.
They make a point which I don't believe is controversial.
Right.
So they were saying, page 14, the 2050, this paragraph 3, or proposition 3, the 2050 target should be implemented for a 100% reduction in greenhouse gases. That was the amendment that was made.
Yeah.
And then at 18, 2 paragraphs up to the bottom, they say, in a discussion about what the UK target should be, they say, 2 paragraphs from the bottom, in all cases, the UK's cumulative emissions over time matters, not just the target for 2050, and that's the point. And then at 19, they refer to an emissions reduction pathway. Those things are then referred to in the Committee for Climate Change report, which preceded the net zero amendment. You have that in the respondent's evidence, starting at PDF page 20.
Sorry, whose evidence is that?
It's the respondent's evidence.
This is Mr. Moran.
Mr. Moran,
Mr.
yeah.
Moran, yes,
Right, so this is the Committee on Climate Change, May 2019, is that right?
yeah, I'm showing you this because it's in the chronologically before the point at which the net zero target was amended in the legislation. What they are about to, I'm going to show you, refer to is the proposition to amend the net zero target, but also the role of the carbon budgets. And the carbon budgets are the steps on the way to 2050, the cumulative impact point.
Right.
So within this document, if I may, at page 25,
Yeah.
this is just so the court has a sense of the way in which, even before the target became more demanding post-Paris, the UK was struggling to meet the carbon budgets. That is relevant because this, of course, is a project, as we know, which is going to create yet more struggle, my expression, in the pre-2050 period. So what we see on page 25, second bullet, middle of the page, reference to the clean growth strategy. That's the government's, as it were, ongoing policy for meeting carbon budgets. And they say this: although the clean growth strategy does not fully close the policy gap to the UK's existing budgets, so we know that they don't close the gap, and that was at the point where the budgets were, and indeed still are, set by reference to a pre-Paris level. They recommend at page 27, second to last paragraph, at that point they were saying we don't recommend changes to the 4th or 5th carbon budgets, but note both were set on the path to the existing 80% target and are likely to be too loose. So what we know is that we are not on target to meet the existing carbon budgets, and they were set pre-Paris and are too loose. And that not on track point again, we see it later on. The other point that's from this document, which is relevant here, is on page 28. In the box at the bottom of the page, there's a couple of bullet points. First bullet point, the second line: action to reduce emissions cannot be left to one government department. Well, that's exactly the point. You then have, put that document down if you may.
Sorry, I'm so sorry. I'm so sorry, Mr. Wolf, forgive me. I couldn't pick up that last reference on page 28. Can you just tell us where it is?
The last is the bullet points at the foot of 28 in the box.
Yeah.
Action to reduce emissions cannot be left to one government department.
Page 28.
See where I say that.
Which page?
Page 28 of the respondent's evidence.
Yeah, we can't find that reference there.
Box 6.2 at the foot of the page.
Yes, we've got that.
Bullet point in the box below the number 2.
Yeah.
Second line.
Oh, I
I'm
see.
taking this very swiftly.
It's the first bullet point,
It's the first bullet.
not the second.
I'm sorry, did I say so?
Yeah, you did. No, I've found it now. Sorry, I was looking at the second bullet. It's the first. Got it. Thank you. Sorry.
In terms of the statutory position, then you've then got, if you go back to the legal materials bundle, tab 1 is the Climate Change Act. This is PDF page 3, and you then have this in its post June 2019 formulation. You have it in section 1 on page 4, the net zero target. The net zero target. You then have on page 5 the carbon budgets, and you've seen a little bit about those. So you now understand, I hope, that in order to give effect to the imperative not just to reach a particular point by 2050, that's the section 1 net zero, we are also concerned about the path to Paris, the cumulative impact over time, and they are reflected in carbon budgets which are already under stress, already not on target, and were not even before the target was, the end goal was changed as it was in June of 2019. So that then is the legal context in which the Oakerview Review report then takes place, partly with an aspiration of net zero, but also with the imperative around the carbon budgets. My Lord, I see the time. I have about 5 minutes more on this topic.
All right. Well, if it's 5 minutes, we'll sit on till no later than 1:05. That's not to put pressure on you. It's simply to say that we will stop at 1:05.
I'm grateful. So with that legal understanding then, that the obviously material Paris, if I could put it that way, has 2 components, one about 2050, but 2 about the way we get there, to some extent translated into carbon budgets and net zero, which we say are then themselves obviously material because if Paris is, so too must these be. We then return to how the Oakerview Review report presented all of these things. I've shown you these materials before. They are all around page 118 of the supplementary bundle. The start of the chapter, which is presenting, sorry, do I mean 118? I don't mean 118. I mean 120, I'm sorry.
That's right. Okay, just a second. Yeah.
So I'm going to go to page 120. The key points, this is paragraph 2.8. Key points over the page, last key point, HS2 could help deliver the government's commitment to bring all greenhouse gas emissions to net zero by 2050. That is because by 2050 it will be in its operational phase when it is, let me put it my way, climate change benevolent, because people are using the train, not flying or driving. But that is to not take any account of the prior period, and more importantly, its legal implications. We then look at 137, which you'll recall was the chapter, that's the heading, Review of Objectives for HS2. And these are effectively identified as the benefits of HS2. But at 149 was the section that I showed you before about wider environmental considerations. That's effectively the climate change section, which told the reader as a matter of fact that there were effectively 2 periods, short to medium term harm, long term benefit, told the reader that they were numerically, effectively it was pretty neutral overall. There's a bit of a debate about quite how neutral it is. But what it then does is it tells the reader, for example at the end of 533, consistent with what we've seen in the key issues point, about how HS2 is part of playing a role in meeting the net zero target. And that, as I've shown you in 2.8, was the benefit. And then we see in conclusion 5 on page 152, the government's 2050 target, ... So this section, whilst it tells the reader the factual position about the two phases, the harm phase and the benefit phase, only tells them the legal implications of the benefit phase. It presents the proposition as if this is legally benign. Whereas actually the situation is more complicated than that because of the obviously material Paris and the obviously material carbon budgets, which is that this is detrimentally impacting on meeting the already stretched carbon budgets in that earlier period. And so what we say is that the decision maker needed to know not just the fact of all of that, but the implications of all of that, the legal implications. If Paris was legally, obviously material and the carbon budgets were obviously material, they needed to know that legal fact. It's not enough that they just told the numbers, particularly in the context of them being told the legal implications of the operational, the benevolent phase. In terms of Mr. Moran's evidence, you have that, you can put away that supplementary bundle and turn to the respondent's evidence. Mr. Moran, I think it's page 7 of the document of the PDF. Sorry, it's page 6 of the PDF.
Paragraph?
23, so 22, 23, no, to say.
Yes.
23, as policies and proposals to reduce greenhouse gas emissions are developed and implemented, and we would say, not just to reduce, their contribution to meeting those things are quantified and published regularly, ... These projections enable the government to monitor progress towards meeting the carbon budgets. And then at paragraph 30, on the effects of HS2, paragraph 30, the UK's climate change framework sets overarching targets, leaving it to the government to determine how efforts be distributed among sectors. The Clean Growth Strategy did not set out one definitive pathway, and you've seen that the Clean Growth Strategy is already off track. Then it says this: any net emissions increase from major infrastructures will be managed within the government's overall strategy for an economy-wide transition to net zero. No doubt about that, no complaint about that at all, but what that fails to recognise is the essential need when considering an infrastructure project like this to take into account its impact on that process. It's not, once you accept that Paris is obviously material to the decision on the project, which we say is the legal kicking off point, then the project needs to evaluate that point and it needs to take into account those impacts for the purposes of deciding on the project here, the whether and if so how to go ahead. It's not legally permissible simply to ignore those things and leave them to the as it were, the after the event process later on. And all of that comes from saying that the Paris implications are obviously material through the process. And the failure here of the decision-making cabinet to be told or to appreciate the legal implications as opposed to the factual implications of the earlier period. So that is the basis on which we say that they failed to take into account Paris, not that they were just not aware of the facts, but they weren't aware of the legal implications. I'm sorry, I interrupted, my lord.
Sorry, in a nutshell, Mr. Wolfe, you're saying that without this information, the decision makers couldn't tell whether it was too expensive in the short run on the carbon front.
Well, yes, too expensive, but also that it's
too
short-run carbon.
Too expensive in the run-up to 2050, that it would be too expensive in terms of the detrimental element of the equation.
Yeah. So they needed to be aware that of the legal context of that shorter period, and then, as my lord says, take into account in the pros and cons evaluation how it would impact on a standing basis of the pros and cons, where what they're effectively told is that this is legally beneficial because they're only told about net zero.
All right. Does that complete your submissions on ground 3B?
I might come back to one or two tiny points, but that's essentially the thrust of it.
All right. Well, let's just, before we rise, let's just take stock. Subject to that additional point or points on ground 3B, you still have to deal with promptness. To assist you, Mr. Wolfe, we can say that you can take your submissions on that question quite shortly, at this stage at least. I hope that assists you.
I'm grateful, Lord. I think I also may need to deal, insofar as it's a point to get from with the Senior Courts Act, Section 31 point.
Yes, again, you can. Yes, well, by all means, you can make submissions on that. You've already, in a sense, touched on it, I think, at one point going through. But yes,
Well, I haven't got a great deal more to go on any view.
no, fine. Thank you for that indication. And then, Mr. Mould, that should give ample time for the other side to be put to us.
I wasn't planning myself to say anything more on promptness than is set out in our skirting.
Right.
In a sense, the point under the Senior Courts Act to some degree speaks for itself. So I was going to focus on two grounds.
Yeah. All right. Well, that's fine. Good. Well, thank you both very much. I'm not tempting fate, I hope, in saying that so far, with one little glitch, things have gone technologically quite smoothly. Thank you all for your help and cooperation this morning. We'll start again at 2:05. Thank you.